We are live. Let's see. And we have people joining us, so we'll give them a few minutes here. We're just going to let everybody get logged in. Everybody's coming online as we speak. So let's just we're going to give everybody a minute or two before we start the program. We're just right at 10 o'clock and we're going to have plenty of time today. The legal update is a little light because the Senate and everything didn't do much last year. So Kevin's going to entertain you as long as he can. And we're just going to give everybody a minute to get logged in before we start. Good morning, Marie. You're welcome. Okay, the login is slowed down just a bit. I know we will have plenty more join us, but I'm Karen Mayfield. For those of you that don't know me, I'm the Executive Director of the West Florida chapter. And we are doing our Manager All Day program a little bit differently this year as everything else. We had hoped possibly to do everything in person starting in August, but Florida, the numbers in Florida aren't cooperating with us, and a lot of people are getting sick every day. So the board of directors doesn't want to put any of our members or anybody at risk. So we're going to do everything, all the Manager All Day programs online. Starting with this one, it is the 2020 legal update, and our presenter today is Kevin Wells with Wells Olah, and Kevin does a lot of our legal updates and he does a fabulous job with them. We are having the other classes, 2 hours of OP, 2 hours of IFM, and 2 hours of HR at the end of August. And if you'll go on our website and look online, and we'll start sending email blasts this week, you can register for the other classes so that you get your credits to renew your license. We know it's a license renewal year. So with that being said, I am going to turn it over to Kevin, but there is going to be plenty of time at the end of the program to ask questions, and also for Kevin to answer questions. So if you have questions during the program, please write them in chat, and then towards the end of the program, Kevin will answer them. And I am going to still be here. I'm just going to mute my audio and my video. And Kevin, if you need anything, just holler at me and I'll be close by. So with that, I'm going to turn it over to you.
And Karen, I think I'm on speaker view where I cannot see the attendees. Do you know how I make it where I can see the attendees?
This is a webinar, so you cannot see the attendees.
Okay. So you guys can
Unless
make all the...
I will look and see if there's a way I can turn on their video, but okay. I don't think there is. It's not a meeting, it is a webinar.
Okay. So you guys can make all the funny faces you want at me. You can attend in your pajamas. Perfectly fine. I can't see you. So again, welcome. If you don't know who I am, my name is Kevin Wells. I will be your speaker for the next 2 hours. We are doing the 2020 legal update. I've been representing condominiums and HOAs and cooperatives for the last 25 years, I think. 23 years. My firm is based out of Sarasota. We have 6 attorneys. The law firm name is Law Offices of Wells Olah. We also have a Venice office that's staffed by my 2 attorneys that are from Venice and Port Charlotte, Mike Cochran and Joe Gigino. So the legal update this year is going to be a little bit on the light side. There just wasn't honestly that much for me to instruct you guys and gals on. We will go through it. There'll be plenty of time for questions at the end. If you would like to enter your question during the course in the chat mode, please feel free to do so. Let's see if I can see the chat. Yes, I can see the chat. So if I can, I'll answer the questions during the presentation. If I see them pop up, there may be a delay. If I don't see the questions at the end of the seminar, we'll go back and then I'll take them in order so that we can go sequentially through the outline. So you'll see on the first page of the PDF handout, which you should all be able to see, we have the 2020 Legal Update course number. The course is being sponsored by Community Associations Institute West Florida chapter. I am the speaker. If you go down to page 2, you will see a whole bunch of chapters. You will see approximately 10 of them that were adopted that to some extent impact community associations. Some of these do not impact community associations whatsoever, but I was told by our dear friends at the department that I had to include them and then lecture on them to some extent. So some of these I included over my concerns that they really had nothing to do with you guys. But as usual, the department went out because they can always fail to approve my course. So they are here. We're also going to go back over one of my favorite topics, UPL, and then something that everyone should know about by now, which is the Florida Administrative Code that is applicable to condominiums. Again, we're going to go over the new penalty guidelines, the fining guidelines, so that everyone knows what the department is looking at and how much they can actually fine the condominiums now. So moving on down, again, what I'm not going to do is read the outline to you by and large, it'd be boring. I'm going to cover what I think is the most important topics so that you guys can follow along with me. You know, I've got my nice screen share on. So the first law we're going to talk about is 2019-001, which had to do with marijuana delivery devices. This is interesting to me because before, smoking marijuana, if you had your marijuana card, you weren't allowed to smoke it. It was not one of the approved methods or delivery methods. So now they've changed the law to make smoking, if the doctor prescribes it as being the appropriate delivery method, it is now legal for people to smoke their prescribed medicinal marijuana. What was important in this law, and it's this very last language right here, the statute does not impair the ability of any party to restrict or limit smoking or vaping marijuana on his or her private property. So in other words, the associations, you can prohibit smoking on common elements. The cooperatives and the HOAs, you can prohibit smoking in your common areas. What this kind of left unanswered, and what a lot of you are going to struggle with, of course, is the people who are smoking marijuana on their lanais, on their balconies, and that smoke smell, and marijuana, I'm told, has a very unique odor to it, that the people on their balconies or in their rooms object to the smell of the marijuana. I've had clients where the owners unit to unit can smell just regular tobacco-based products when they're smoked. Marijuana, I think, is going to be quite a bit worse. We don't really have a lot of case law on that. What I'm telling my clients is I recommend you get out in front of it. You know, we have been successful in restricting smoking in the lanais, the balconies, patios. The way I typically approach it is grandfather existing smokers and then have the rule or the deck amendment apply to everyone who takes title after it's been adopted or recorded. So again, a lot of good information on smoking marijuana. If you don't have a smoking rule, it's probably something your board should look at and get in front of it before you actually have a problem. The next law that went into effect, Chapter 2019-0057. Most of you have probably heard about this. This is the Assignment of Benefits Law, sometimes just referred to in short term as AOB. So the legislature determined that the assignment of benefits were creating a problem for a lot of the insurance industry. So they passed some very detailed and complex laws to regulate assignment of benefits. The law goes into a lot of details. They give you definitions for assignors. That's typically, in our perspective, going to be the association. Assignee is going to be the company that is going to be performing the work. Assignment agreement is going to be the document they ask you to sign. Certain requirements that must go into that assignment agreement now. If not, if you jump down to D, it'll say an assignment agreement that does not comply with this subsection is invalid and unenforceable. So I guarantee you what happened, all the companies that use assignment of benefits, they went to their attorneys as soon as this law came out, and they probably said, you know, Mr. or Madam Attorney, please revise our agreement, make sure they fully comply with what the new statute requires. And I'm assuming within a matter of days, they had new agreements in place. You'll notice the now 18-point uppercase bold-face type that must be included on all the assignment of benefit agreements. This language should concern people before they sign them. They need to really understand what they're giving up when they sign an assignment of benefits. So this language is supposed to be, in my mind, a warning of what the assignment of benefits agreement basically provides in a very short, one paragraph type provision. It also gives certain cancellation rights. So again, that's new, and I think that's going to be to the benefit of our community associations. Scanning on down, again, when you have time, read the assignment of benefits. I don't know how much it actually impacts managers and directors on a day-to-day basis. Obviously, when you're looking to sign one of these contracts, my recommendation is if you don't understand what you're signing, contact your association attorney. Make sure that the attorney reviews it and gives you a full explanation of what the assignment of benefits contract will do and won't do for you. I've had clients that have used them successfully. I've had clients that absolutely regret signing them. So again, just make sure that the boards understand what they're doing, which is why I think the main problem I saw, people really did not understand what the assignment of benefits contract did for them. You'll notice it says this subsection applies to assignment agreements executed on or after July 1, 2019. So in effect, that will apply to everyone now who signs an assignment of benefits. Moving on down. The court also, and this is fairly new, they've increased the jurisdictional limits of the court system. So before, for example, county court, the jurisdictional limit was monetary damages up to $15,000. Right now, we're at monetary disputes up to $30,000, so they've doubled it. In 2023, that dispute is going up to $50,000. So the county courts are going to become a lot more useful. There's going to be a lot more litigation in the county court system than in the circuit court system because of the increase in these monetary or jurisdictional limits. Law and ordinance. So again, this was 2019-0082. Law and ordinance, I'm assuming everyone knows what law and ordinance actually is. Your insurance agents should be explaining law and ordinance to your boards, to your community association, so that they can make an informed decision whether or not the community association desires to purchase law and ordinance or not. I am told by my colleagues in the insurance profession that the cost of law and ordinance has gone way down in the last 4 or 5 years. So if before the law and ordinance was too expensive for your association, I recommend you revisit it with your insurance agent, your insurance professional. Have them quote and explain to you what law and ordinance does. A lot of people fundamentally, again, just don't understand what law and ordinance coverage provides them, what benefit it provides them. So again, I encourage you, have your agent come out, explain to your boards what law and ordinance coverage does, and make them revisit the price quotes as far as what law and ordinance will cost. Now, 627-7011 was more designed for the homeowners policies, not really the association's policies. It's for Kevin Wells homeowner. This is now disclaimers that must go on my personal homeowners insurance policy. So again, that's interesting to us in the community association because it reminds us that we need to revisit law and ordinance. Can we afford it? Is it, effective to spend that kind of money on law and ordinance? Sometimes it is, sometimes it isn't. All depends on your unique facts and circumstances. Again, flood insurance, there's now a disclaimer that has to go on the policy regarding flood insurance. For example, my home is not in a floodplain, but I've recently purchased flood insurance because it's exceptionally cheap for me. And I have a lot of construction going on around probably 1,500 acres around my house. So again, it reminds us, look at flood insurance, look at your exposure, look at your risk, and then make a business decision. Does it make sense for your boards to spend money on flood insurance, even if you're outside of a floodplain? They tinkered with 617. Most of you, 99% of you, your associations are not-for-profit corporations. That means you're regulated by 617 as well as 718, 719. So 617, you should be familiar with it. 617-0831 is the statutory indemnification and liability of officers, directors, and employees. What this statute basically did is, if you read down to the second line, any reference to directors in these sections includes directors, managers, or trustees of a corporation organized under this act. However, and this is the language I thought was really interesting, the term director does not include a director appointed by the developer to the board of directors of a condominium association, a co-op, or an HOA, or a timeshare. So I thought that was very interesting that they've excluded developer appointed directors to condos, co-ops, and HOAs. Moving on down, and I know I'm going way too fast, but I'll try to keep up this blistering pace. I don't see any questions put in the chat yet. Hopefully Bill Ashby is no longer making faces at me, but you never know, he could be. This actually caused a little bit of controversy, Chapter 2019-120. So what this basically did, the legislature intended to encourage the sustainable cultivation of vegetables and fruit at all levels of production. So the state law says, except as otherwise provided by law, a county, municipality, or other political subdivision of the state may not regulate vegetable gardens on residential properties. So of course, what happens is immediately all the homeowners who read the blurb in the paper about this ran out, started planting their vegetable gardens, and then they got violation letters from their HOAs saying you can't do that. The homeowner said, yes, there's a new state law that says we can, and the homeowners are incorrect. The HOAs and the condos are not counties, municipalities, or other political subdivisions of the state. Therefore, this law does not apply to them. So you are in effect still traveling under whatever your HOA documents say. So again, this law does not apply to HOAs, condos, and cooperatives. Let's see, local ordinance law. I won't cover that because it's really not applicable to community associations. Read it at your leisure. Same thing happened with the tree ordinance. So again, Chapter 2019-155 amended Section 163045 regarding tree pruning, trimming, or removal of trees from residential properties. So it says a local government, which right there should tell you that is not a condominium co-op or a HOA. So a local government may not require a notice application, approval, permit, fee, or mitigation for the pruning, trimming, or removal of a tree on residential property if the property owner obtains documentation from an arborist certified by the International Society of Arboriculture or a Florida licensed landscape architect that the tree presents a danger to persons or property. Local government may not require a property owner to replant a tree that was pruned, trimmed, or removed in accordance with this section. I have been told by some of my larger HOA clients that certain counties and certain towns are taking the position that this law does not apply to the common elements or common areas of the HOA or the condominium. So in effect, HOAs and condos felt that they had the ability to get an arborist opinion saying the tree presents a danger. Therefore, we could cut it down without having to go to the county or the town. The county or the town, at least some of them, and again, check with your local government, are taking the position that because the common elements are not residential property, that this law does not assist the HOA or the condominium. So again, check with your local government, make sure what their position is and whether or not they believe this law applies to your common area or common elements. 2019-164, termination, contraction, or expansion of CDDs. We all know and love our CDDs. They actually perform a great service to our communities. This law is fairly unique in its application to just CDDs. So CDD managers, if we have any on the seminar, make sure you read this new law that, again, applies to termination, contraction, or expansion of CDDs. I won't read it for the rest of you, just be aware that it's out there. Fire safety, 718-112-2. Again, obviously this applies to condominiums. An association must ensure compliance with the Florida Fire Prevention Code. That is your duty. As do residential condominium buildings, that is a high-rise building. As defined under the Florida Fire Prevention Code, the association must either retrofit a fire sprinkler system or an engineered life safety system as specified in the Florida Fire Prevention Code. Notwithstanding chapters, again, this is the old language. The language they added, if you go down, the local authority having jurisdiction may not require completion of retrofitting with a fire sprinkler system, and this is the language they added, or an engineered life safety system before January 1, 2024. And again, previously the deadline was January 1, 2020. So just be aware that if you're a high-rise condominium, there may be requirements, depending on when your building was built, that you have to upgrade to the engineered life safety system. This is entirely separate and apart from perhaps you did the opt-out vote on the fire sprinklers. This is a separate requirement for the engineered life safety system. My understanding of the opt-out language, it only applied to fire sprinkler systems. There is no opt-out for an engineered life safety system. And again, whether or not you have any compliance issues is something you need to look at and determine. If you have out of compliance issues, you have until January 1, 2024 to rectify them. Let's see, moving down. 718-1085, certain regulations not to be retroactively applied. What they added here is if you go to the last sentence, for the purposes of this section, the term common areas means stairwells and exposed outdoor walkways and corridors, but does not include individual balconies. In no event shall the local authority having jurisdiction require retrofitting of common areas with handrails and guardrails before the end of 2024. Now we get into the really fun stuff. So if you've been kind of paying less strict attention than you were, I would encourage all the condominium managers to really kind of zoom back in, because this is the new fine and penalty rules that apply. And again, I'll be very specific. This rule only applies to condominiums. This rule does not apply to HOAs. The cooperative people in the room, you still have to comply with the old fines and penalties. So this is, again, specific only to condominiums. So we're in a rule. So this is a rule adopted by the department. Affirmative or corrective action means putting remedial procedures in place to ensure that the violation does not reoccur. So when you're required to take affirmative or corrective action, not only do you have to cure the existing problems, you have to put procedures in place to make sure that the problems or the violations do not reoccur. And this is, and again, that's concerning enough because that's very difficult to do given the scope of these rules. But the next provision actually causes me great concern. So affirmative or corrective action means making any injured person whole as to the harm suffered in relation to the violation. So if you have a unit owner who has suffered some sort of financial or other harm, the division can order the association to make that injured person whole, which is very concerning, because I think that very much broadens the jurisdiction of the division, so that now included within their authority is the ability to order the association to make people whole, which again is concerning. Move down to minor violations. One of the first things I want you to look at is this is the list of minor violations. 1, 2, 3, 4, 5, 6, 7. So there are only 7 minor violations. The first thing you're going to notice is it only applies to unit owner controlled associations, not to developer controlled associations. So if the division has reasonable cause to believe that a minor violation has occurred, a notice of non-compliance will be sent to the association. So what concerns me there is you don't necessarily even get the chance to respond. If the division has reasonable cause based upon only what the complaining party says, they can issue a notice of non-compliance. The notice of non-compliance shall provide the association with a reasonable period of time to comply with the rule. The notice of non-compliance shall identify the violation and provide an investigator's contact number and email address so that the association may contact the division to obtain educational assistance and an educational conference. What's missing here is I see no ability to contest the division's reasonable cause determination that a violation occurred. So basically, they are judge and jury. The association is solely responsible for achieving compliance. Failure to do so, or failure to comply with the notice of non-compliance, will lead to further enforcement action as permitted by law. The following violations shall be considered minor violations. So let's work through them. Budgets. Failure to disclose the beginning and ending dates of the period covered by the proposed budget. And the division is very literal. You better have on your budgets the start date and the end date. So if you're a typical association, you're on the calendar year, your budget better say January 1, 2020 to December 31, 2020. If you have fiscal year 2020, you are in violation. So again, I want to be very clear, and I still see this once or twice a year. You better have a start date and an end date printed on your budget. Failure to disclose periodic assessments for each unit type in the proposed budget. So if you have different unit types, you better disclose the assessments by unit type. Distributing candidate information sheets consisting of more than one page. Again, seems like a silly violation, but as managers, we all know it's just one page. Ballot does not list candidates alphabetically by surname. Again, seems simple. Everyone knows you list the candidates by last name or by surname. Unfortunately, I still see this minor violation occurring quite frequently. Outer envelope information verified before the date of election. So again, we all know outer ballot information must be verified at the meeting. There is a procedure to do it the day of the meeting before, but quite frankly, I've never seen it used. So again, normally you validate the outer ballot information. The committee does it from the floor of the meeting in the same room. Failure to disclose the amount required to fully fund each reserve account as of the end of the fiscal period covered by the annual financial statements and the manner by which reserve items were estimated and or the date the estimates were last made in the annual financial statement or turnover audit. Failure to disclose in the year-end financial statements the manner by which reserve items were estimated and or the date the estimates were made. And again, the simple thing here is if you're using CPA, they automatically include the statutory language. This violation most often occurs when the members opt out of the financial statement required by law, and you're basically just doing a cash report. If you do the cash report, whoever is doing it must make sure to include the statutory financial disclosures. Last but not least, failure to disclose the method of allocating income and expenses in the annual financial statement or turnover audit. Again, that's more of just a simple housekeeping measure that no one should be making that mistake. Now we get to the fun part. What happens if you commit one of these 7 minor violations? Upon a determination of an association's failure to comply with a notice of compliance. So again, understand we're a little bit down the road. So you've committed the violation, the division has sent you a notice of compliance, and now you failed to comply with that notice of compliance. Only then will an enforcement action be taken, and the division shall impose a civil penalty of between $5 and $10 per unit for each minor violation. So that's going to be your range, $5 to $10 per unit for each minor violation. The penalty will be assessed beginning with the middle of the specified range, so $7.50 per unit, and adjusted either up or down based upon any aggravating or accepted mitigating circumstances pursuant to the rule we're about to cover. The minimum total penalty to be assessed shall be calculated according to the guidelines, or $500. Again, this is the minimum, whichever amount is greater, and no event shall a penalty be more than $2,500, the statutory maximum for a single violation. Guidelines in this rule are based upon a single count violation of each provision listed. Multiple counts of the violated provision or a combination of the listed violations will be added together to determine an overall penalty. So let's say an owner files a complaint, you didn't include something as silly as the start date and end date of the budget, and they say, hey, I'm filing a complaint because the association did not do this for the last 3 years. Each year would be deemed a separate violation, and the division could impose a penalty of $7.50 per unit per violation going back 3 years. So again, be aware, I've seen owners kind of stack these violations. All right, moving on to penalty guidelines. And this is, again, where it kind of gets interesting. You'll notice it states in 61B 21.003, the purpose of the disciplinary guidelines is to provide notice to the affected parties of the range of penalties which may be imposed for each count. So again, the purpose of these guidelines is to give everyone notice of the penalties that the division will impose. So you're on notice as of the time they adopted these penalties, I believe last year, you're on notice of the penalties. Multiple counts of the violated provision or combination will be added together to determine the overall penalty. Let's see what else is important here. So now when we move to 2, penalties will be assessed beginning with the middle of the specified range. So now we're talking about other than minor violations. We're talking about major violations. So they're going to assess in the middle of the range. The range is $10 to $30 per unit for each violation. So we would assume, starting in the major violations, that they're going to start the conversation as far as how the association shall be penalized at $20 per unit. Again, the minimum penalty is $500 or whatever the guidelines say, whichever amount is greater, and no event shall a penalty of more than the statutory maximum be imposed for a single violation. The absence of any violation from this rule shall not be construed to indicate that the violation does not cause substantial harm or is not subject to penalty. So even if you commit a violation of the chapter and it's not listed, you can still be fined. You simply look at the closest violation that is listed. So let's go through these major violations, and there's a lot of them. I'm not going to touch on each and every one of them, but I do think we need to touch on several of them. Insufficient or incomplete accounting records. Failure to maintain separate accounting records for each condominium. So again, if you're a multi-condominium with 5 condominiums, you have to have separate accounting records for each. And this is a big one, I think. For all your boards that just focus and their only real concern is we have to keep our assessment number, you know, the magic number, $800 a month. We have to keep it the same. So it is actually a major violation of Chapter 718 for the assessments not being sufficient to meet anticipated expenses. So again, this is a violation. If your budget is inadequate, the division now has at least the authority to impose a violation of $20 per unit because when you adopted the budget was too low. Now again, let's be clear. I don't think the division intends to violate anyone if your insurance premium comes back $20,000 higher than you anticipated and you had no reason to know that. I don't see the division imposing a penalty for that. Likewise, if your attorney fees come back at $30,000 and you budgeted $500, again, I don't think the division is going to look at that as being a major violation. But when the board adopted the budget, if that budget was inadequate when adopted and everyone knew that there's no way that budget is going to meet the expenses, so again, a reasonableness standard, that's what I think the division is going to come in and issue a violation and impose a penalty. Assessment not based on the share stated in the declaration, that's pretty self-evident. Obviously, you assess according to what the declaration says. Assessments not properly apportioned among multiple condominiums. So for you managers of multi-condos out there, again, I recommend you always have your budget run by the attorney and let them look at several of these items, especially when you're taking over a new associations, a new multi-condo association. I strongly recommend you run it by the attorney. If you simply do it the way the last management company did it, you know, you may be in violation. This next one really confused me, and I don't know why the division is sticking their toe in this pond. So it is now a violation for the association to fail to charge interest on past due assessments. So if your association does not charge interest, you can be fined up to, again, $20 per unit per violation. I don't know if the division would look at each unit as a separate violation or if it was simply look at maybe you have 200 units, it'd be one violation because you didn't charge interest on any of them. But again, failure to charge interest on past due assessments is now a violation. What I'm telling my clients when you have a collection case, and of course the owners always ask the associations to waive interest, waive late fees, I'm cautioning my clients, and again, this only applies to condominiums, I'm recommending you not waive interest. Plain and simple. I don't want to have some other owner who's mad because maybe last year the association would not waive the interest applicable to his unit. Don't waive interest. If you want to waive late fees, assuming you have authority to charge them, that's fine, waive late fees. If you even want to waive the equivalent amount in attorney's fees, or you calculate the interest, let's say the interest is $200. Rather than waive $200 in interest, I would recommend you waive $200 in attorney's fees. So the net would be the same. We're just strictly complying and avoiding a complaint for failure to charge interest. Now, because I'm an attorney, I like to nitpick words. I don't know if failure to charge interest, if this violation would be applicable to an association waiving interest. So to flesh that out for you, the association initially charges the interest, owner asks the associations to waive it to settle the account, association waives it. I think we can make a pretty good argument that we did charge it, we just elected to waive it. My concern there is I don't know how the division will receive that argument. We have yet to make it. I don't have any associations that were violated for this through today. Doesn't mean it's not coming, it just means it hasn't happened. I don't know how the division would receive that argument. So I would much rather tell my clients, look, waive the equivalent amount of attorney fees if you're interested in waiving. That way we don't even have to get into a back and forth with the division. Developer or other owner improperly excused from paying assessments. I think every attorney I know has always cautioned every association, never waive assessments. You can waive attorney fees, you can waive late fees, but simply do not waive assessments. It is a statutory violation. Improper use fee. So again, make sure that, if you're charging use fees for use of the common elements, that you have authority to charge a use fee. I want to see the authority. I want to see an owner vote. There's a statute 718.111.4 that tells you when you're allowed to charge use fees. Make sure you comply with it. Failure to maintain adequate fidelity bonding. You think that's simple, but I actually had an association that got violated because they initially had sufficient fidelity bonding. Then they levied a very large special assessment for a construction project. They didn't tell their insurance company. They didn't increase their fidelity bonding to cover this very large special assessment. And of course, it was just one of those owners who went and filed a complaint with the division. So again, anytime you're borrowing maybe a large sum of money or levying a large special assessment, go back to your insurance agent, make sure that if you need to, you increase your fidelity bonding for the term that that money is going to be in your possession. Improper transfer fees or security deposits. So again, if you're charging a transfer fee, 718.112.2i is very clear. You can only charge a transfer fee if you have authority to do so in your documents and you have the authority to approve the transaction, whether it be an owner transferring title or a landlord leasing their unit. You have to have authority to charge a transfer fee. And by the way, you don't get out of this rule by calling it an application fee. It's still going to be deemed a transfer fee. Most of my clients don't charge security deposits, but if you do, make sure you have authority in your documents to charge security deposits. If not, again, a violation. Levying late fees without documentary authority. A lot of my clients and even a lot of management companies and managers just make the naked assumption that the associations can automatically impose a late fee. That would be wrong. You only have the authority to charge a late fee if the condo documents expressly say so. So again, don't charge late fees unless you have authority in your documents. Imposing fines without proper notice and an opportunity for a hearing. Imposing excessive fines, improper suspension of voting rights without proper notice. So again, make sure you're complying with all the statutory procedures. Now this is a big one. And again, a casual reading, allowing an ineligible person to run for the board. That's easy, right? Not so much. The problem here is, of course, we all know, you look at the bylaws, some bylaws require that you have to be an owner or the spouse of an owner. Sometimes it'll say the designated voting representative of an owner. Those are the bylaw requirements we typically see. To be clear, if your bylaws don't require a director candidate to be an owner, there is no state law that requires it. So if your documents require an owner, requires a director candidate to be an owner, then that's what most people think of. What a lot of people overlook, and again, good managers don't do this, is their account with the association has to be current on that 40th day prior to the election. So I assume all the good managers in the audience are checking on that candidate eligibility date, the 40 days prior to the election. When I, Kevin Wells, owner, submit my notice of candidacy, before you put my name on the ballot, you must determine that my account is current, or else state law says you cannot include my name on the ballot. So again, make sure you're checking for that. Something else state law says, and this is kind of touchy. So again, pay attention for the next few minutes. You're fined for allowing ineligible persons to run for the board. So when you put their name on the ballot and then you ask owners to vote for them, one of the things that is not permitted, if I have a felony conviction, I am prohibited from serving on the board. So if I have a felony conviction, my civil rights have not been restored for at least 5 years, I am not allowed to serve on your board. And I wish I could ask for a show of hands, I can't. How many of you are running criminal background checks on your director candidates? I paused dramatically. I have very few associations doing this. So once that, if you do somehow allow, if your documents require a candidate to be an owner, or if you're not running criminal background searches, then of course, the busybody of the condominium does a criminal background search or hears through the grapevine that Kevin Wells is a convicted felon, and they bring it to the board, they file a complaint with the division. The division now, obviously under this rule, can impose a fine because the association didn't verify eligibility in the documents, make sure the account was current, and also conduct criminal background searches. Again, I would say less than 5 or 10% of my associations are conducting criminal background searches on director candidates. I've had a lot of managers say, well, Kevin, that's okay. Before we approved him as an owner, we do criminal background searches. So when we approved John Smith back in 1990, back then he didn't have a felony conviction. Okay, what's happened in the last 30 years? What's happened in the last 5 years? I'm telling my clients, if you intend to comply with this rule, you better be conducting, and tell your owners in advance on the notice of intent to be a candidate sheet, advise them. Florida law requires us to conduct at least criminal background checks or searches on all director candidates. That way, maybe you can avoid the embarrassment of someone being, determined to be a convicted felon. So again, that's something I see a lot of people overlooking. So no questions at all about that. All right. Let's see, failure to obtain competitive bids on contracts that exceed 5% of the budget, obviously. I think we're all doing that. Failure to include a schedule of limited common element expenses in the budget. So if you have limited common elements that the owners are required to spend money on, you have to have a separate schedule of those expenses. Failure to prepare a separate budget for each condominium operated by the association as well as for the association. So again, here we're talking about multi-condominiums. If you have 5 condos being operated by a multi-condominium, you must have a separate budget for each condominium as well as a budget for the association. So you would have 6 total budgets. A little COVID cough there, don't worry. You don't get any viruses through a computer, right? I don't think. Different virus, okay. Failure to include reserve schedules and the proposed budget. So again, you must include in that initial draft of the budget a fully funded reserve schedule. That fully funded reserve schedule must go into place unless the members vote not to fully fund or do something other than fully fund. So when the board adopts that initial budget, you must show fully funding. You have no choice. Question: at what point in the election do you do the background check? I tell my clients do it prior to actually including the names on the director election ballot. So I would do it early. You need to have a background check company that can turn it around within a day or two. And again, that should be very easy to do if you have a good background check company. Moving on down, using association funds for other than common expenses. So if you're using association funds for something that's kind of off the wall, you're exposed to a fine, a penalty. To be clear, there is actually an arbitration case that says if you're using your association funds to buy donuts and provide other just niceties at the membership meeting, there is an arbitration case that says that's ultra vires or beyond the corporate purpose, and therefore you're subject to a violation. So again, be very cautious about that. Contracting with a service provider, contracting with a service provider owned by a board member. So if you're hiring a service provider, which is not defined by state law, exactly what that means, but if the association is signing a contract with them, you better be asking, is that service provider, Wells Landscaping, owned by Kevin Wells, who is a board member? If you're not asking that question, you're exposed to a penalty. Failure to disclose a conflict of interest. So we have very detailed conflicts of interest laws in the Condo Act, 718-3027. Directors and officers have an obligation to disclose a conflict of interest. Make sure you're doing that. Most of you know you can't have debit cards, and most of your banks told you cut up your debit cards. They cannot issue them to you. Let's see what else is interesting on here. A lot of this is common sense. If a director candidate ever hands you their written notice of intent to be a candidate, you are required by law to hand them back a written receipt. So again, if they hand it to you, they hand it to the manager, you're required to give them a written receipt. Question: would a self-certification work in the felony determination? Please don't take this the wrong way, but you're going to ask perhaps a felon to tell the truth and certify that he's not a felon. So my answer is no. Is that better than doing nothing? Yes. I don't know how the division would look at a self-certification. I think it's better than doing nothing, marginally so. But yes, I think it's problematic to ask a convicted felon to tell the truth about whether or not they're a convicted felon. So again, I think the only safe way to comply is to have a criminal background search done on each director candidate. Let's see. Ballots included a candidate who is ineligible. Ballot not including an eligible candidate. So again, all of you condo managers out there, the people you put on that ballot is of fundamental importance. Once that ballot goes out, I think you have real exposure here that if you included or failed to include an eligible candidate. Voters allowed to rescind or change their previously cast ballots. And again, to be very clear, we're talking about only director election ballots. So once I have mailed my director election ballot in, or once I hand it to the manager when I register at the door, you cannot give it back under any circumstances. So again, this only applies to director election ballots. If I'm a member and I'm voting on waiving reserves through a proxy, I show up at the meeting and I've previously handed my proxy in and I want to change my vote. Yes, people who are voting by proxy or have cast a ballot on the waiving of reserves, they can change their vote up until the time the tally is announced. Once you announce the tally, the voting is closed. Let's see. Outer envelopes not checked against a list of eligible voters. Again, all managers know that's a requirement, very straightforward to do. Let's see, anything else in here that's really interesting? Now we're going to get into estoppels. Failure to timely provide an estoppel certificate or failure of the certificate to contain all required components. Now think about that. So of course we all know if you fail to timely provide the estoppel, that's a violation. Okay, that's a given. You also lose your right to recover your fees for the estoppel. Now, think about the second part. Failure of the certificate to contain all required components. My concern here is Joe Bank submits their estoppel form. It's 3 questions, very simplified. If the association signs, answers the 3 questions, and sends it back, did the association just violate state law because the estoppel form did not contain all the required components? I don't know the answer. That's going to be up to the division one day. What I try to do for my clients is avoid the complaint. So your association should have an estoppel form that's been probably drafted by the management, vetted by the attorney at least once as to the form, and then the manager will fill in the specifics as to that unit. If you use your in-house form, you avoid any complaint here. If you start using other people's forms, and let's just say the sale goes sideways, they don't like your answers, owner's mad at the association or at the management for giving out what they view as being negative or maybe even incorrect information, they file a complaint with the division. Now the division has jurisdiction, or at least the authority to impose a fine. If you have your in-house estoppel certificate and you know that's been vetted by the attorney, you're going to be in compliance. Violating a fiduciary duty. So again, directors, officers owe fiduciary duties. If they violate a fiduciary duty, they can be fined or penalized. So be very much aware of that if you're a director or an officer. Failure to maintain official records. We all know what the official records are, 718.111.12. You as the manager are probably obligated by contract to maintain them. Make sure you do. It's an area that if you get into litigation with an owner, the first thing most attorneys are going to do is start submitting official records requests, and they will pretty quickly determine whether or not your official records are in compliance. Failure to timely provide access to records. Failure to allow scanning or copying of records. Failure to maintain records within 45 miles, requiring a unit owner to pay a fee for access to association records. And you notice I emphasize the word access. You can charge a fee for making copies in certain circumstances. You are not allowed to charge a fee for simply providing access. Most of my clients, once they get burned by an attorney for an owner, they will come back, have my firm prepare an official records inspection and access rule. Your association should all have these rules in place. If not, they have real exposure to someone filing one or more complaints with a division, and then division imposing fines for each one of these violations. Again, remember, $20 per unit is going to be where they start, and each one of these violations will be deemed a separate violation. So again, make sure you've got your official records inspection and copying rule up to snuff. One in the middle of the page, failure to timely provide annual financial report or statements. Again, this is something very easy for the division to come in and impose a fine. 718.111.13 has hard deadlines you must comply with. Hard deadlines. If you cannot provide proof that you complied with those hard deadlines, you absolutely will be fined right out of the gate. First violation, $20 per unit. It's very easy for the division to come in and say, okay, send us proof that you either provided the letter or an actual copy of the financial statement timely. If you can't provide that dated letter, you will be fined. I had 3 associations fined last year for this violation. To circle back around, of course, this year that deadline for condominiums was extended by emergency order. That deadline, I think, is now well past. I think the extension was 60 days, but I'm not sure. So again, make sure you comply with those hard deadlines. Let's see what else we want to talk about. Now we're getting into financial reporting. Most of your CPAs will comply with everything you see. Let's see. Failure to fund reserves in a timely manner. That's very straightforward. Failure to follow the proper method to waive or reduce reserve funding. Again, we all know that pretty much by rote. Of course, if you're getting your reserves, if you're going to waive or partially fund them, we all know on the limited proxy, you have to have that disclaimer, that ditty required by 718.112 that cautions owners about waiving or reducing reserves. Using reserve funds for other purposes without proper unit owner approval. So this typically happens come October. The condo association is running low on money and they feel they have no choice but to go borrow money from reserves. They think it's not a violation because it's just borrowing. They're going to pay it back. That would be incorrect. It absolutely is a violation unless you've obtained the prior approval of the owners. So the way this should work is you go to the members, call a special membership meeting, you ask them for authority to take a certain amount of money from reserves to fund an operating shortfall. If you get a majority of the quorum to approve it, you're golden. If you do not, then do not take the money from reserves without prior membership approval. Using reserve funds for other purposes. So again, assuming your straight line methodology on your reserves, if you've got a roof reserve, you can only use that roof reserve money to replace your roof. If you have a leak in your roof, year 2, that money is not taken from reserves. That would be operational. So if you have, again, straight line or component methodology for funding your reserves, you have to use the money only on that specific purpose. If you have pooled funding, slightly different analysis. If you pooled, let's say, 7 reserve accounts, then within those 7 pooled accounts, you can spend money on any one of those 7 purposes. A lot of people think if you pool your reserve accounts, you can still use reserve money for an operating deficit. That is incorrect. Make sure you don't do that. Using special assessment funds for other purposes. So what I like to do here is when the board is levying a special assessment, they absolutely need to use their attorney. We can assist with drafting a special assessment resolution. We can clearly delineate the use of the funds being raised by the special assessment. We can put in some what I call wiggle language so that you can use the funds on related purposes. And again, your attorneys can really do a great job for you here. Make sure to use them. Going up to questions, sorry, I think I missed a few. We talked about the self-certification. What if spouse of board member owns company that you've contracted with? Again, I would encourage you to go back and read 718, I think it's 3027. That will directly answer your question. Next question, would we be able to cross-utilize approval to use other reserve funds? Not quite sure I understand the question. So if the membership each year votes to cross-utilize reserve accounts, what that means is as to all your established reserve accounts, if one is short, you can take money from another account to pay that shortfall. Again, that's only within the reserve accounts that have been cross-utilized. That does not allow you to take money from reserves and spend it on an operating shortfall. So I think, Kathy, that answers your question. If not, give me a call. But again, if you're voting to cross-utilize, to give you an example, if you're replacing the roof, you come up 20,000 short and you have existing money in a road reserve, then you can take the money out of the road reserve and spend it on the roof replacement shortfall. If you pass a special assessment for a construction project and you do not use the money, do not use all the money, what can you do with the money? Again, read your documents. I've seen documents that specify exactly what has to happen with the surplus in the special assessment. So the first thing I would tell you to do, read your documents. If your documents are silent, I tell clients to do one of 2 things. Refund the money back to the owners, which I don't like to do because it causes problems. Or I think you're within the rights for the board to then vote to apply it as a credit, either on this year's assessments or next year's assessments. In effect, you're still giving the money back to the owners. You're just doing it in the form of a credit toward their regular monthly or quarterly assessments. Going back to the handout, special assessment notice does not state the purpose of the assessment. So again, most of you, I hope, are using your attorneys to draft that notice. There's certain statutory language, 718.116.10, that you have to put certain notice language on the notice and agenda of the assessment. Moving on, let's see. So we're still within the finding and penalizing resolution. If you can demonstrate aggravating or mitigating circumstances, the division will go up or down in the finding amount. Aggravating circumstances are below. So again, take a second, read that while I get a sip of water. Mitigating circumstances, take a few seconds, read that. B1 should kind of make you laugh. The violation or harm was related to a natural or man-made disaster. I guess COVID-19 would fall within that. So that's a mitigating circumstance. And then finally, subsection 4, in addition to the penalties established in this rule, the division reserves the right to seek to recover any other costs, penalties, attorney fees, court costs, service fees, collection costs, and damages allowed by law. I don't know why the division is in that business, but the rule clearly gives them the right to do so. Let me check how we're doing on time. 11 o'clock, so we have a whole nother hour we have to spend, technically a little bit less than an hour. So let's dive into UPL. So UPL is, again, if you guys have ever heard me speak, it's kind of one of my pet peeves. The unlicensed practice of law in Florida is a third-degree felony. So take a few minutes, read this language right here. I hope by highlighting it, I did make it where you guys couldn't read it. Read this language, and I think what you're gonna determine at the end of reading it is it's clear as mud. So take a few seconds, read it. All right, I'm assuming everyone's a speed reader. We're done. So again, the takeaway is it's a third-degree felony. So fortunately, because this is somewhat vague and then not really clear as to what UPL is, we have a Florida Supreme Court opinion 2015. As most of you more seasoned managers know, there was actually a 1996 version of the same opinion. So this has now been updated from 96 to 2015. And this goes through the 14 activities specifically addressed by the UPL committee. So again, we have 14 activities that are very, very specifically addressed within the community association industry that will tell us exactly what UPL is and what UPL is not. What I want to make sure everyone understands perfectly, UPL applies to, of course, you as the manager. Don't commit a crime. It's really that simple. As we learned in kindergarten, don't do bad things, don't commit crimes. It also applies to your directors. It applies to your officers. It applies to your committee members. So the takeaway from this is, of course, as a manager, don't commit a crime. And 2, managers should encourage their directors and officers also not to commit UPL. And from your perspective, more importantly, the directors and the officers should not expect you as a manager to commit a crime. So again, that's about setting, to some extent, boundaries that you're not going to commit a crime if asked to by your client. So the first 3, preparation of a certificate of assessment, once it's turned over to the association's lawyer, preparation of the certificate assessment during foreclosure, preparation of the certificate assessment due once a member disputes in writing to the association the amount alleged or owed. In the 96 opinion, the court found that the preparation of these certificates was ministerial in nature and did not require legal sophistication or training. Therefore, it is not UPL for the manager to prepare these documents. Clear enough, right? No questions about that? Outstanding. Number 4 is honestly difficult. And let's go into 4. Drafting of amendments and certificates of amendments that are recorded in the public records to declarations, bylaws, articles, when such documents are to be voted upon by the members. In the 96 opinion, the court held that the drafting of documents which determine substantial rights, and again, remember that language there, drafting of documents which determine substantial rights is the practice of law. The governing documents set forth above determine substantial rights of the community association and property owners. Consequently, under the 96 opinion, the preparation of these documents constitutes the unlicensed practice of law, meaning a felony. So that's straightforward. Don't prepare deck amendments. Don't prepare amendments to the articles, the bylaws. Don't prepare the certificates of amendments. So we all know not to do that. That's straightforward. I tell my clients, if the manager, the board member wants to take the initial stab at drafting the amendment, perfectly fine. Just make sure you send it to the attorney The attorney can then look at it, make revisions as necessary, send it back to you. That way you have a record of it. So I think once you've sent it to the attorney has maybe tweaked it, sent it back to you. I think any stink of UPL has been knocked off that amendment. I think you're perfectly fine. However, if you have a president who drafts an amendment to the bylaws, takes the board from 3 people to 5 people, staggers the term, sends it out to the members then vote on it, then the manager sends it to the attorney to review so that we can prepare the certificate of amendment, yes, in that case, I think the president has committed UPL. That's a major problem in that now the president is exposed to the state attorney perhaps charging him or her with a felony. So again, I'm perfectly fine with my clients doing the initial drafting, sending it to the attorney. We then make the changes, send it back out to the association. You've got the attorney looking at it. We all know attorneys are really good at one thing, which is billing our clients. I can go back for the 23, 25 years I've been practicing through my billing software. I can tell you everything I've ever done, when I did it, how much I charged, and who I did it for. So attorneys are really good at billing. That means we have very detailed records so that if an owner does say, hey, the president committed UPL by drafting this deck amendment, you can always go back to the attorney. We can verify, note, we've looked at it, we revised it, we sent it back, no UPL. Now, let's make things more complicated. That's the easy part of this conversation, by the way. The hard part of the conversation is, again, you'll notice it calls out by name, the declaration, the bylaws, the articles, when such documents are being voted on by the members. So going back to that 96 opinion, it said drafting of documents which determine substantial rights. All right. So how many of you have had associations draft rules and regulations? Most of you, right? How many of you have had those rules and regulations determine substantial rights of your members? So I am not saying that all rules determine substantial rights. Clearly, that is not so. If the HOA is drafting a rule that says you've got to take your garbage can out to the curb not less than or not more than 24 hours, and you've got to bring it back up to the house within 48 hours of pickup, is that determining substantial rights? Of course not. Now, if the HOA is adopting a rule that restricts leasing, maybe you have to lease a minimum of 6 months, not more than twice a year. You can't lease more often than a certain number of times, or a certain number of people only can be in each bedroom, 2 adults per bedroom, where you can't lease during the first 24 months of ownership. If you do that via a rule, which attorneys generally don't recommend, we recommend you put it in the declaration, but if you do it by a rule, did that rule just determine substantial rights? I think so. So be concerned that if you have rules determining substantial rights, my advice is run it by the attorney. Once you have the attorney billing record, the attorney looks at it, we can then get involved to make sure you're doing everything appropriately. We can caution you if not. So again, any rules you have that determine substantial rights, my advice is run it by your attorney. That way there's no allegations of UPL. Now, if you're an HOA, of course, you know that there's a new law, relatively new. It goes back to January 1, 2018, that if you're adopting an amendment to your governing documents, and again, this only applies to HOAs. Governing documents include rules. So if you're adopting an amendment to your rules, you have to show the changes with strike-throughs and underlines or use the amended and restated format. So again, that's consistent with the deck articles bylaws. But once you've proposed that rule and you now go once the board has adopted that rule, assuming the board has rulemaking authority, the new state law requires you to go record that rule in the public records. So you have to have a certificate of recording to record that rule in the public records. And the state law says the rule is not effective unless recorded. So again, for you HOAs, I'm assuming everyone knows about this relatively new law. You're in compliance with it. As to rules that predated that state law, you're no requirement to record them, but rules that post-date that state law, yes, you must record them. And again, once you record them and the rule is substantially determining substantial rights of the owners, I think you might run into a UPL problem. So again, be very cautious about this, involve your attorneys, make sure that you're not inadvertently trampling over UPL. And just to be clear, that requirement to record rules only applies to HOAs. It does not apply to condos or cooperatives. It is only an HOA requirement. And again, I'm assuming everyone knows about that because it's getting a little bit long in the tooth going back to July 1, 2018. Moving on down, I'm not going to read all of these to you. I just want to make sure you're aware of them. The court found that determining the timing, method, and form of giving notices of meetings requires the interpretation of statutes, administrative rules, and governing documents, rules of civil procedure, and that such interpretation constitutes the practice of law. So again, timing, methodology, or form of giving notices, that is according to the Florida Supreme Court UPL. Modification of limited proxy forms. So again, this was addressed in the 96 opinion. So managers are allowed to, or associations, directors and officers, change the name. You can phrase a yes or no question concerning waiving reserves or waiving compiled, reviewed, or audited financial statements. So again, simple yes or no questions on those two topics are fine. Phrasing a yes or no voting question concerning carryover of excess membership expenses, perfectly fine. Phrasing a yes or no voting question concerning the adoption of amendments to the articles, bylaws, or condo documents. So again, simply yes or no questions, you're fine phrasing them. Anything that gets more complicated or gets into drafting, you should run by your attorney. If you're not using the department's form, absolutely use the department's limited proxy form. Your proxy form is required to substantially comply with the division's proxy form. It's available on their website. So if you're not starting with that division limited proxy form, you are probably going wrong. So again, make sure you start with their form. If you do, you will avoid 80% of the problems I see with proxies. Let's see, for more complicated modifications, the court found that an attorney must be consulted. If no discretion is involved, if it does not constitute the unlicensed practice of law to modify the questions on the division's form. On the other hand, if the question requires discretion in phrasing or involves interpretation of statute or legal documents, the CAM may not modify the form. All right, moving on down. Let's see. 7, read when you have time. 8, determining the affirmative votes needed to pass a proposition or amendment. Determining the owner votes needed to establish a quorum. In the 96 opinion, the court found that determining the votes necessary to take certain actions, where the determination required the interpretation and application of the Condo Act and the Community Association's documents, would constitute the practice of law. So again, what I encourage my managers to do is simply have me write you a quick letter. You know, this is the vote. I will be as specific as I can. If it says something like the majority of the total voting interest, I will tell you majority means more than half. If you have 100 units, that means you have to get 51 voting interest. If you suspended voting rights, you know, we'll have a separate conversation about that. So again, you know, your attorney should give you very detailed, specific guidance on how to calculate that vote. Construction lien documents, number 11. And, you know, this is where you're putting a new roof on the clubhouse. You're, you know, making physical alterations to real property, land, or buildings. In the 96 opinion, the court found that drafting of the notice of commencement form, and you all typically are handed this form by the roofing contractor, and they go, here's a notice of commencement, sign it. And most of you will then hand it to the president signs it without really understanding the document or even who completed it. I've never understood how this is not UPL. So when that representative of the roofing industry, when they complete that form for you and they give it to you and then you have the president sign it, I think that representative of the roofing company most likely committed UPL. Why that's really bad for you guys is if that notice of commencement form is completed incorrectly, that will be to the detriment of the association. So again, it won't necessarily be to the detriment of the contractor. It's going to be to the detriment of the association. So make sure that even on something as simple as a notice of commencement, have your architect, your engineer, your attorney, make sure these forms are done correctly. If not, I guarantee you it will lead to a lot of trouble and a lot of financial exposure for your association. What a lot of people don't understand about construction lien law in Florida, in my opinion, as humble as it is, the construction lien law is written to protect the contractor, not the association, not the owner. So if you're putting a new roof on your clubhouse, you either don't complete the notice of commencement at all, or you complete it incorrectly. If the tile supply company sends the notice to owner to you, you receive it, you don't understand it. The association then pays the roofer in full. You don't get any releases from the tile supply company. The tile supply company absolutely has the right under the construction lien law to lien the individual units to enforce payment. Because as you all know, the unit owners own the common elements and undivided shares, not the association. So if the association makes a mistake, doesn't get the final release of lien from the tile supply company, the tile supply company timely sent the notice to owner to the address on the notice of commencement, the tile supply company now will have the right, if the general contractor stiffs them and doesn't pay them, to lien every one of the condominium units to enforce payment. So again, make sure you guys are using professionals when it comes to real property improvements. There is some real exposure here, and doing this for 20 plus years, what I've seen is when business is good, this is not a problem. Contractors are flush with cash. They have plenty of money to float job to job. They're making a lot of profit. However, when times get tough, contractors start having financial problems. They start having inability to pay their suppliers unless they're successful from job to job to job. Again, this is where the condo association or the homeowners association really has exposure to that contractor not paying the suppliers, the subs. The suppliers and subs then go after the associations. If you're sitting down with your attorney for the first time after receiving a threatening letter from the supplier's attorney, it's probably too late for many attorneys to help you. The law is very clear. Unless they screwed up on the front end, the advice from your attorney is probably going to be, yes, you're going to pay twice. Because Florida law basically says if you pay the general contractor without receiving final releases of liens from all the subs and suppliers, by paying that general contractor in full, you have violated state law. So again, be very careful with construction lien law. It's kind of counterintuitive, and it doesn't say what many of you think it says. Number 12, in the 96 opinion, the court found that the preparation of documents that established and affected the legal rights of the community association was the practice of law. Further, in Sperry, the court found that the preparation of legal instruments, including contracts, by which legal rights are either obtained, secured, or given away, was the practice of law. Therefore, it's the standing committee's opinion that it constitutes UPL for a CAM to prepare such contracts for the community association. Again, obviously, CAM should not be preparing such contracts. If you do so at great risk to yourself. Let's see. Finally, the catch-all, number 14, any activity that requires statutory or case law analysis to reach a legal conclusion. So again, that's the catch-all. If in doubt, if you're committing UPL or if your director or officer is committing UPL, I encourage you, run, don't walk. Talk to your attorney. Make sure that you're not exposed to a UPL criminal complaint, because I guarantee you in each and every one of your associations, you will have people that perhaps dislike you, that dislike your board, dislike your officers. And if they are given the ability to cause grief, they will cause you grief. So again, be very careful. Let's see, there's some questions that I didn't see that were popping up. Let's see if I can go down to them. We talked about the cross-utilization question. We talked about that one. All right, I'm caught up. Moving on. Let's see about the Warren case. Nope, no need to talk about that. And the next one we've already talked about under 14. And that is it. How are we doing on time? We have 11:20, so we still need to fill about 15 or 20 more minutes. Karen, if you're there, we can unmute everyone and maybe have them ask questions.
In the webinar part, I don't think I can.
Okay. I guess we can encourage everyone to submit questions via the chat. So if you have any questions, now is a good time for you to get out the old keyboard, type them in. I see a question from Tess. What exactly is an assignment of benefits for? Where I see it most often used in the community association industry is the building has some sort of catastrophic event, either a fire, more likely it's going to be some sort of water or sewage event where there's substantial backup of water and sewage into the unit, the adjacent common elements. Maybe it's going to flood several units, and you call out the contractors that they remediate, they remove the water, they address any existing mold or mildew issues, they dry the unit out. That's where I've seen it most often, is in those catastrophic type events following sewage or water backups. I've also seen them more recently is there's a group that are reaching out to associations. What they're saying is if your tile roof suffered damage as a result of the last hurricane, or maybe you had a tornado, they will take an assignment of benefits. They promise you a new roof. They then pursue with the insurance company a claim against your applicable policy, whether it be the wind or the hurricane, and then they pursue getting you a replacement roof. To do that, they have you sign, again, the assignment of benefits contract, and that's how they get, the right to pursue that on your behalf. I'm not going to take a position and say if it's good or bad. It just depends on the association and the circumstances. So again, that's where I've seen the assignment of benefits most often. Next question. Karen, do you have a question?
All I was going to say is if they do have a question, I can unmute. To go through unmute everybody would take quite a while. There's not an unmute all, but
Okay.
if it's their hand, I might be able to unmute them.
Okay. And again, the easiest way to do it is just type your question into the chat. That's going to be the simplest way for us to keep track of everyone. What documents are required to be posted on the association's website? Well, first, you only have to post documents on your website if you are a condominium with 150 or more units. So again, if you have less than 150 units, you're not required to post anything. You're not even required to actually have a website. So again, be very much aware, only if you have 150 or more units in your condominium. That list is specified in 718. I want to say it's probably about 15 different documents. If you want to email me offline, I'll be happy to send you that statute so you can look it up directly. If you simple Google condominium website document list, I guarantee you'll find it within the top 5 search results. So again, but understand, you only have to have a website with the required documents if you're 150 units or more. Is there a rule of thumb when the condo docs are more stringent than 718 or vice versa? Which one trumps? My answer is it depends. So this is one of the most complicated areas of condominium law. If the Condominium Act is procedural, for example, if it's telling you how to elect directors, the Condominium Act will trump or take priority over your documents. So that's the simple one, procedures. If it's substantive, in other words, my firm, we litigated a case on the requirement that directors could not serve more than 8 consecutive years. If it's substantive, now the analysis becomes much more complicated. You have to determine, did the legislature intend the law to be applied retroactively? If they did, then you have to look at, is that law being applied retroactively an impairment of existing contract rights? And again, that's factually and legally intensive. Do your condominium documents have what's called Kaufman language in them? So again, it can get really complicated as far as, does the law automatically supersede your documents, yes or no? Obviously, that's something that if it's important to you, you need to, again, run, don't walk to your attorney. They've litigated, and I can think of at least 12 state laws within 718 that have been declared unconstitutional because they were purported to apply retroactively. Again, the most recent one was the Termination Statute, 718-117. The Florida Supreme Court said that could not be applied retroactively. So again, that's a very great question, and it's a very hard question to answer in this type of forum.
Kevin, I was looking through the Q&A, and I don't know if you've answered these. Is the debit card only for condos?
No, debit cards are prohibited for condos, co-ops, and cooperatives. No one should have debit cards.
Okay. Where can I find information on the condo association most include in an estoppel letter certificate? Where can I find the information the condo association most include in an estoppel letter certificate?
Okay. Yep. Hold on one second. That's in 718. I want to say it's right after 116. So again, we're talking about just condominiums. Hold on one second and I'll find it for you. I want to say it's 116 subsection 8. My well-used version of the Condo Act. Yeah, let's just jump to 116. Riveting legal research right here, folks. You're watching magic in action. So let's see. It is indeed 718.116 subsection 8. So that's the required estoppel information. And I will forewarn you, some of those questions need to be answered by the attorney at least the first time. We just covered the UPL. So again, what most of my clients have done, they send me the form certificate. We answer the legal questions. We send it to you one time, not each and every time, just once. Once you have the legal answer to those questions, the manager or the board can then fill in the information specific to that request.
Okay. A couple more. Would merging 3 different proxies into one single proxy constitute UPL?
I don't know if I understand the question, but I only recommend associations use one proxy. Don't mail out multiple proxies for one meeting. I'm fine having 6, 7 questions on one proxy. Again, if you start off with the division's proxy form, your form must substantially comply with it. Again, you can put as many questions on the proxy as you choose to. There's no limit, really. I've had one HOA that was voting on document amendments. We had 48 questions, which I thought was excessive, but the client loved it. So again, you can put multiple questions on a single proxy. Is that UPL? My answer is going to be, of course, it depends. I can't give you a straightforward answer without knowing the facts better.
Okay. I think I've got one more here. An owner, and I don't know if an owner is changing his windows, can he sign the NOC?
So the owner is making the real property improvement. The windows are included in his unit. The owner is indeed allowed to complete the notice of commencement because that has to do with his personal property. So again, that's not UPL for the owner to do it. Make sure you do it correctly. The difference is when the condo association does it, you're a corporation. A corporation has to follow different rules than an individual unit owner when it comes to that sort of provision. So an owner can do it individually, but when you're dealing with a corporation, I think it is UPL for the manager or the president to complete the notice of commencement because you're doing it on behalf of the condo association.
Okay. And the last thing on this Q&A is there's an anonymous attendee that asked the question, where can I get a copy of this presentation? Let me just say, if you're showing up as anonymous, and even those of you that have called in with your phone numbers, you need to send me an email and let me know who you are, what your phone number was, because we do pull a list at the end of this of who was online, and that's what we use to give you credit. We can monitor who you are if you sign in properly or with your name, and how many minutes you were on the presentation, and that's how we are able to comply with the DBPR requirements. There are no copies of this presentation other than the handout that you were sent. I've got a couple more that have come in. Kevin, are you up for it?
Sure,
Okay.
we have time to burn.
Okay. Do you know if a lot of associations are using e-voting for election voting?
I'm seeing more now go to it. E-voting, I think, allows people to vote via online software or a website. So it's very interesting right now in COVID to allow owners the opportunity to vote online. In fact, I just looked at this morning, I have a modest-sized HOA, about 50 units. What they're doing is they're going to go to a certain vendor, and if you Google online condo HOA voting in Florida, you'll stumble across the top 5 vendors easily enough. So they're going to go to that vendor and offer their owners the opportunity to vote online. You notice how I worded that. It's an opportunity. You cannot force your owners to vote via the online platform. It's at their election. And the online software generally is pretty good. They've got it set up where they're in compliance with state law, and basically you pay a fee. They send you the forms you need to make it happen. It's almost turnkey. It's simple. Of course, the fee is high, but so is not having membership meetings and voting. Now, what I've got a lot of my associations doing, especially the smaller ones, there is a state law. It's 617.0721. What it allows people to do is if the board adopts guidelines and procedures, owners are permitted to attend a membership meeting and vote via platforms such as this, Zoom. They can vote and be counted as if they're physically at the meeting. So again, 617.0721, I want to say it's subsection 3. The board adopts a resolution, which again, have your attorney assist you with. You establish guidelines and procedures, and you can allow owners to attend a membership meeting, be counted as if they're physically at the meeting, and then cast their vote by saying, hi, I'm Kevin Wells, the procedure is in place. Maybe I hold up my driver's license. Maybe you say, hi, Kevin, we know you, absolutely cast your vote. I vote in favor of the declaration amendment, and it can really be that simple. Now, if you don't have 617.0721 and you don't have the board resolution authorizing remote voting, which again is different than online voting, that's software based. The remote voting is just, remote communication is just authorized by board resolution. Owners can still be permitted to participate as far as talk, but they can't vote unless you comply with 0721. So again, I think for a lot of my smaller associations, that's a relatively cheap, easy process to implement. You can do it within about 7 to 10 days. And again, it seems to work fairly well with smaller associations. If you're looking at a couple hundred units, I don't think it's going to work as well. I would encourage you to go to online voting. And yes, you can have a hybrid, but then it gets confusing if you try to do both. So I think for large associations, use the online voting, an entirely different process and procedure. Smaller associations, I think, can get away with remote communication, which is voting via Zoom.
And that answers her follow-up question on that. So we'll move on. One last one under Q&A is, could you please go over what NOC and lien waivers are?
Sure. Notice of commencement law. It's a very complicated law. My partner, Paul Olah, is board certified in construction lien law. So when you're making a real property improvement, and let me use my HOA for an example. We're planting trees, bushes, about $10,000 worth of trees and bushes. That's a real property improvement. If they were simply mowing the grass, that's not a real property improvement. If you're putting a roof on your clubhouse, real property improvement. If Kevin Wells is remodeling his bathroom by putting in new kitchen countertops, new sinks, real property improvement. So anything that's a real property improvement, the construction lien law is going to apply. Now there is a minimum threshold. Last time I looked it up, it was $2,500. Below that, you don't have to comply with it. Above that, you do. There's certain exceptions which are weird for like replacing your AC unit. You don't have to necessarily comply with it, but for the real property improvements most of the associations are dealing with, roof replacement, for example, again, you have to really use a professional, because when you read the construction lien law, it will make absolutely no sense to you. It's a horribly drafted law. It's massively complex. So again, I would just encourage, as far as threshold information, as a manager, as a director, just have in the back of your head, if you're making a real property improvement, use a professional, whether it be an attorney, architect, engineer. We all have all the forms. Some of the forms are actually in the state law. Again, using those forms without understanding them is problematic. So I encourage you, go to your professionals, have them sit down with you for 30 minutes to an hour. It will be some of the best money you've ever spent. Same thing if you're making a kitchen improvement or a bathroom remodel to your unit, your home, same law applies to you, by the way. So if you're an owner making real property improvements to your home, I would also encourage you, go have someone explain to you how to comply with the state law, because your wallet, your pocketbook is on the line if you don't comply with the law.
Okay, I think we're done. Well, there's another one on Q&A. We've got them in chat as well. No, that was just Jody thanking us for the answer. Let's go back to chat. Do you remember where we stopped?
Let's see. We halfway down the 3 proxies we answered. Okay. If I am asked as a CAM to prepare documents such as bylaw changes without attorney reviewing, do I walk or run? What I would encourage you to do is educate. I would hand a copy of either this handout or the UPL decision. The name is on the handout. Hand that to your, whoever's asking you, your president, and say, you may not understand this, but you just asked me to commit a felony. I can't prepare that bylaw amendment unless it's going to be run through the attorney. I'm not going to lose my license. I think you have to educate your boards, because I don't think they understand what they're asking you to do. This is one of the reasons to have your presidents attend a board certification course, so they can have explained to them, just like I did, but in more detail, what UPL is and what it is not. If I'm a manager, is it worth losing my license over and possibly being prosecuted for a felony? Absolutely not. So the first thing I would tell you is educate. Encourage the president maybe to call the attorney and ask their corporate attorney what he or she thinks about it. Obviously, they're going to toe the party line, explain UPL, and say, no, your manager, while you can prepare it, it has to go through the attorney before it goes to the members. So that was midway through.
The next one is, would you be sharing this presentation by email? No, we are not sharing. The only thing we are sharing is the handout that you received. We did not record this because it is for credit, so we won't be posting it up anywhere. Sorry about that. So glad you're here, Maria. My board president takes the agenda down immediately following the board meeting and will not post the minutes on the website. Is that legal?
So nothing wrong with taking down the notice of an agenda after the board meeting is over. I think everyone does that. I know, for example, my association, as soon as our board meeting's over, I go pull up the stick with the date, time, place, just because I'll forget if I don't. So that part's perfectly fine. I will not post the minutes on the website. Again, the only time you have to post minutes on a website is if your condominium has 150 or more units. And then you have to post them, in my opinion, within a reasonable time period. If you're less than 150 units, there's no requirement to post minutes on a website. So I think that just depends on the number of units in your condominium.
Okay. Next question. Have you ever done workshops on Florida Statute 723?
Not generally. I can never put enough people in the room to do a 723 seminar. So generally I don't do them. I'm not opposed to doing them. I just generally can't put enough people in the room to make it worthwhile.
Okay. And we answered Jody's question. Let's see. You say no debit cards. You did. Yeah, we already answered this about the debit cards and HOA. So that's been answered. No debit cards for anybody. What would be required for a board resolution?
I don't know if that's for the remote communication voting or for online voting. Both of those are controlled by state law as far as what has to go in. Again, I would encourage you use your attorney. So the remote communication is 617-0721. The online voting is 718-128. So again, you'll find those spelled out in state law.
Okay, and Stephanie Curtis just wrote in and let me know she was on via phone. So I've got you covered, Stephanie. Kevin, if you answered my question, I had to step away and deal with a problem and missed it. Would you please repeat it? Now, Kathy, I'm not sure what your question was. We've had several. So can you rewrite it at the bottom or in the chat and we'll get down to it? Up to how many proxies can one person hold for annual members meeting?
Oh, that's interesting. So it depends. And I know people get tired of me saying it depends. So there used to be a law a long, long time ago, and the law said one person could not hold more than 5 proxies. A lot of the documents that were written when that law was in effect, they put that into their bylaws. And then they changed the law. Right now, there is no limitation on how many proxies a single person can hold by law. So if you look at 718, 719, 720, no limitation whatsoever. You may very well have limitations written into your documents. So again, if your documents create an independent limitation, and again, the one I most often see is you can't hold more than 5 proxies, your documents should be complied with. The only exception I would tell you is I'm aware of an arbitration case that went through this analysis for condominiums. And the arbitrator said, the only reason your documents have that 5-person limitation is that's what the law used to say. That's when general proxies were encouraged and limited proxies were not the norm, because limited proxies now for condominiums have to be used for virtually everything. This requirement no longer makes sense. Therefore, the arbitrator invalidated the cap of 5 proxies per person. So again, for condominiums, the answer may be different if your documents limit it to 5 people. If you're in an HOA, then again, it's whatever your documents say. And as to a co-op, I would have no problem applying the condo arbitration case to a co-op because you also have to go through mandatory non-binding arbitration.
Okay. Next question, if a developer does not establish reserves before the developer turns over the community, is it required that the membership must vote to establish reserves, or does a board have the ability to establish and then membership vote in favor of fully or partially funding?
What an interesting question. So my assumption and given my answer is this question pertains to an HOA. The question would not make a lot of sense if it's a condo because the reserves are required by state law. So my assumption is this is an HOA. To answer this question, an attorney would have to look at what your documents say. They would have to look at the law in 720 that was in effect when your documents were first recorded. And then once they've looked at the documents and the law then in effect, then they could give you an answer. So effectively, I can't give you a blanket answer. I can tell you, look at your documents, look at the law that was in effect when your documents were recorded. You then have to determine if you have Kaufman language. Most original developer documents do not have Kaufman language. So to answer your question, look at the documents, look at the law in effect when your documents were recorded, absent Kaufman language, that's going to be your answer.
Okay. One of the managers is asking for my email. My email is in response to, I sent you the handout and the evaluation forms yesterday, but I'll repeat it. It's Karen, K-A-R-I-N @CAIWestFlorida.org. So, and then we've got several people saying thank you. When posting minutes on the website, must they be approved or can they be a draft?
I think that's discretionary. Again, you're only required to post minutes if you have 150 units or more in your condominium. I'm aware of no requirement to post the unofficial minutes, just the approved minutes. So if your under 150 units in your condominium, you can post whatever you want to, whenever you want to. There's no requirement to post anything. If you're above 150 units, then you're required to post your minutes within a reasonable time. And I've always seen only the approved minutes be posted, not a draft minute.
Okay. We just have a couple more. Kathy Jones's question was about construction of lien guidelines. Do you remember answering that question? We've had several, Kathy, I'm not sure.
No, we did talk about the construction lien law. Again, if you're spending more than $2,500 to make a real property improvement, and I'm not certain that's the amount, I haven't looked it up in a couple of years, but if you're spending money on real property improvements, my advice to you is make sure you comply with the construction lien law. Use your professionals, your attorneys, your architects, your engineers. Make sure you're using the right documents. And it can get quite convoluted. It really can. So we could spend 2 hours just talking about construction lien law problems and provisions.
Okay, and the last question I have here is, where in the presentation is it referenced about the debit card?
That was in the fining provisions. So I'm not sure where. Somewhere page 9, page 10, somewhere in there you'll find something that says you can't have debit cards. It's also in 718, 719, and 720. If you, here's a debit card. It's 718.111 subsection 15. That's on page 10. You'll see it about 1, 2, 3, 4, 5, 6, 7 lines down. And it gives you the statutory reference where you're not allowed to have debit cards for condos. And again, remember that rule only applies to condos. But there is a similar law in 719 and 720.
I think we've answered. I am using a company Zoom account okay, never mind, that was to me. The rest of the questions have to do with them, the way they've logged in. Again, if you guys have logged in and you have a question as to whether or not you're going to show up your name, if you are using a telephone number, we can't really track your telephone number. All you need to do is send me an email, tell me how you logged in or what the account might be, and so we can track it on the report, or give me the telephone number and we can track it that way. We'll do our very best to match you up. But again, we'll know you're on this email because you will send me an email giving me that information. And again, my email is Karin, Karin, at CAIWestFlorida.org.
I see one more question, Karen. It says, how do you recommend a lifestyle community make purchases for events? Credit cards. So again, the state law is very specific. It only prohibits debit cards. There is no prohibition on credit cards. So what a lot of my clients simply did is they flipped over to credit cards, and that's perfectly legal. Why the legislature sought to eliminate debit cards and still allow credit cards, I don't understand the reasoning. I'm sure they had some, I just don't know it. So again, use credit cards, go out and open one in the corporate name. You're like any other corporation, you absolutely can open up credit cards. Spending limit obviously is an issue you want to look at seriously, but yeah, use credit cards.
Wonderful. And I think that's all. That's all the questions. There were a lot.
Absolutely. And that allowed us to fill the last 20 minutes of the presentation. So fabulous. Again, thank you for having me be your presenter, your instructor. Everyone, please make sure you return those evaluation forms. The board of CAI looks at each and every one of them, or at least looks at the comments. So make sure that you return them. I would greatly appreciate it. And thanks again for having me be the instructor.
Kevin, as always, thank you so much for being the instructor on this. This is, you always do a wonderful job with any class, but especially the legal update. So we greatly appreciate it. And to all the managers, thanks for logging in. Go to our website if you need more classes and you will see them up. And again, send me an email if you logged in via another account or via phone. Karin at CAIWestFlorida.org. Thanks, everyone. Take care.
All right. Thank you, everyone.